Court is ready to hear argument in 19-634, Rogers versus Bagley from Cameron County and the 13th Court of Appeals District.
May it please the court, Mr. Davis will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal.
Thank you, Mr. Chief Justice, and may it please the court. The two primary issues in these cross petitions are whether Mr. Bagley's claims are healthcare liability claims and whether Section 1983 preempts the expert report requirement in the Texas Medical Liability Act. The Court of Appeals correctly analyzed the first issue, finding that the claims are healthcare liability claims, but it erred in finding preemption. If I could start just briefly with that first issue. The Act defines healthcare liability claim broadly. It has three basic elements. The first is that the claim be against a physician or other healthcare provider. The second is that the claim has to be for treatment or lack of treatment or deviation from a standard of healthcare or safety. And then the third element is proximate cause. And this court's precedent confirms the breadth of that definition. For instance, in Loaisaga versus Cerda, the court explained that it's an expansive definition and that as long as the facts alleged, looking beyond the labels that the plaintiff might put on a claim, as long as the facts alleged could support a claim for breach of a standard of care, it is a healthcare liability claim, even if the plaintiff doesn't mention a standard of care. And of course, that's significant here because the plaintiff has tried to say that these are Section 1983 claims. They don't implicate a standard of care. But of course, they take place in the setting of a mental health facility during the provision of treatment. And
how, Mr. Davis, how relevant is the setting in which a violation of a constitutional right takes place? I guess I'm trying to get to where the second and third element of healthcare liability claims is relevant when we're talking about a violation of a constitutional right.
Sure, Justice Guzman. And I think the fallacy of the other side's argument is that a Section 1983 claim and a healthcare liability claim are mutually exclusive. And that's not the case. If there's a claim for excessive force in the healthcare setting, the question will be whether the force was in excess of the need. And that will be measured in the healthcare setting by the accepted standard of care. And so it's not just that it happened in a mental health facility, but the fact that it was part and parcel of the provision of care to Mr. Bagley. And this court's precedent confirms that. So for instance, in Psychiatric Solutions and Texas West Oaks, those both involved instances in mental health facilities, use of a restraint. Now, those were claims by employees against the employer, but it's even more clear because it's the claim by the patient himself.
So, Mr. Davis, let me ask you something. So, of course, we have to look at cases that are beyond just this one in structuring whatever kind of a rule we're going to structure. So let's say if we have a situation where you have a patient who is in a healthcare facility, but it's not a mental health facility. They're just there for regular, let's say, suspicion of cancer, for example. And the doctor that's treating the patient gets wind that the patient is having an affair with his wife. And so he walks into the treating room and let's say he punches him out. Or let's say when he's drawing his blood, he intentionally draws the blood in a way that's going to cause some pain. Let's go back to the first one where he punched him out. Is that a healthcare liability claim?
Well, I think it'd certainly be a closer case. And I guess part of the analysis, and we know this from Diversicare, is whether expert testimony would be needed. And you probably wouldn't need expert testimony to know that punching somebody is not the right thing to do. But in
Well, you
this kind
probably
of,
would need an expert report. Let's say if the patient ended up having a heart attack or whatever the injury was, to connect the act with the injury.
sure, and maybe I misunderstood the hypothetical. If it does have some healthcare component, and especially if there's some question of causation, yes, expert testimony will be required. And so I think it again points to the breadth of that definition in the act. But here we're comfortably within that because we're talking
But my
about.
question is, in that case, if your answer is that that would not be a healthcare liability claim, then how could we structure a rule to make sure that that which is not the clearly not the provision of healthcare would not inadvertently be scooped up in the rule?
Well, I guess it would go back to the statutory definition, and it might be a matter for the legislature because the way that the statute defines healthcare liability claim does bring in a lot of different claims. So I understand the concern about how far that might extend, but I really don't think the court has to get into that here. And, it might be a matter for the legislature to take up.
Well, I think the legislature's made clear it has to do with the provision of healthcare. The problem is oftentimes the difference between determining what's the provision of healthcare and what is just basic assault or sexual assault or whatever is not an easy line to draw.
Sure, and I take your point, Justice Lehrman. I would just say that here there's no question that it goes to mental health care and also safety under this court's precedent. And in Diversicare, the court pointed out that it's not within the general knowledge what restraints are proper in a healthcare setting, what medication is proper. Those are matters for expert testimony. Now, if I could switch to the preemption issue, unless there are other questions on the first point, we start on preemption, as we do with the first issue, with a presumption in the defendant's favor. There's a strong presumption against federal preemption of state law. And here we're talking about implied conflict preemption. So the question is whether the state law actually conflicts with the federal law such that it undermines an objective of Congress. And that's not the case here. And I think there are two cases that are probably most relevant to this analysis. The first is this court's decision in re Global Santa Fe, and the second is the US Supreme Court's decision in Felder versus Casey. So if I could start with Global Santa Fe, because I think that case really is very close in relevant part to this case and should guide the analysis. The Global Santa Fe was a Jones Act case, so not a 1983 claim, but the Jones Act is a similarly broad federal statute that allows plaintiffs to seek relief. And the question there was whether the Jones Act preempted Chapter 90, provisions in Chapter 90 of the Civil Practice and Remedies Code. And the first of those provisions that the court addressed was an expert report requirement, very similar to the expert report requirement comes from the federal cause of action. And the court, again, correctly concluded that that expert report, that procedural report, expert report requirement was not preempted because in either forum, the plaintiff in a Jones Act case was going to have to put on evidence from an expert to establish his claim. And again, the same thing is true here as I was just mentioning. Now, the court in Global Santa Fe did go on to find that another provision of Chapter 90 was preempted. And that was a substantive provision providing that the plaintiff had to show a certain level of impairment. And the court said, well, that adds something that's not in the Jones Act, and it provides a burden on a plaintiff that wouldn't otherwise exist. So that is preempted. And so that takes me to Felder versus Casey, which is another case from the US Supreme Court, this one, that found preemption. And that case is distinguishable on several grounds from this one. And we addressed that in the briefing. I'd like to highlight just a few points about Felder. The first is that the state law in Felder specifically protected governmental defendants, and it was a 1983 suit there. And so, of course, 1983 specifically allows for liability against state actors. And so right there, there was a direct conflict with what the state law was doing and what the federal law was doing. Another distinction, and of course we don't have that here because the TMLA applies regardless of who the defendant is, state or governmental or non-governmental. The second distinction is that in Felder, the plaintiff couldn't even get in the courthouse door unless he complied with the statute. He had to provide notice and then wait a certain time. And of course here, the expert report requirement kicks in only after the plaintiff has filed suit. And then a third point about Felder is that the state law there was an exhaustion requirement. Not only did the plaintiff have to go to the defendants he was trying to hold liable under Section 1983 and provide notice, it had to ask them to settle the case. And only if that settlement process failed could the plaintiff sue under Section 1983. So for all of those reasons, Felder just doesn't apply here. The plaintiff here has tried to characterize the expert report requirement as an exhaustion requirement, but that just doesn't fit the description of that concept. Another point I would note here is that the Fifth Circuit in Passmore has confirmed its view of Section 74.351, that's the expert report provision of the TMLA, as a procedural requirement. So that means that in federal court, it doesn't apply because in an Erie scenario, federal law governs the procedure, state law the substance. But as I mentioned earlier, we're of course in the reverse Erie scenario here. So a ruling in our favor would be consistent with what the Fifth Circuit has said about the nature of that requirement. Those are the two primary issues in the case. And if I could just briefly touch on the remaining two issues. The first of those is that the Court of Appeals appeared to limit its preemption analysis to the excessive force setting. And that's not correct. It's just not the case that Section 1983 preempts the expert report requirement in any of the scenarios we're talking about here, regardless of whether the plaintiff has labeled the claims excessive force, deliberate indifference, failure to supervise. The analysis is the same. And then the final point is that the Court of Appeals correctly concluded that the Rio Grande State Center could appeal the denial of its motion to dismiss even after the non-suit because that motion necessarily requested the affirmative relief of attorney's fees and costs. And that's reflected at page 86 of the clerk's record. That's part of the motion to dismiss. It quotes Section 74.351B, which uses the word shall to confirm that when a defendant moves to dismiss successfully, it obtains both dismissal with prejudice and an award of reasonable attorney's fees and costs. And so for that reason, the Court of Appeals, again, was correct on that point. Those are the points that I intended to cover in my opening time. Unless the court has further questions, I would reserve the remainder of my time for rebuttal.
Any other questions?
Just let me ask you to comment on, do you think that what do you think is the significance of the difference between the intent behind the Medical Liability Act, which has to do with doing away with frivolous lawsuits and the efficient administration of justice, and in 1983, which is meant to compensate individuals whose constitutional rights have been deprived by state actors?
Certainly, the statutes have different purposes, and the question for preemption is whether they have conflicting purposes. And just in the way that the Jones Act and Chapter 90 have different purposes, they also don't conflict with respect to procedural provisions.
Any other questions? Thank you, Mr. Davis. We'll hear from the respondent.
May it please the court, Ms. Klein will present argument for respondents.
May it please the court, I'm Katie Klein, and I'm here representing Mr. Bagley in reference to the wrongful death of his son, Jeremiah. And we are here, and I would like to focus on two elements that are extremely important, and I think that the justices have correctly identified as making significant difference in this case. And one is, what was the goal of Chapter 74 versus the reason why 1983 was enacted going back to 1871, and what was the nature of the conduct that caused the death of Mr. Bagley. We're here because the Court of Appeals did sustain the trial court's motion to dismiss and denied the motion to dismiss on the grounds of preemption and said that 1983 preempted the application of 74.031 to a claim for excessive force or failure to train or supervise. We also brought a cross petition seeking to review the determination that our claim was a healthcare liability claim. And I think that was where Justice Lehrman's questions were focused. The state has attempted to convert a civil rights claim into a healthcare liability claim, and it is significant that in 44 years, no one else has ever tried to do that. There is not a single case that has been reported in which this position has been taken. The only outlier being Edwards versus Phillips, which is an unpublished case out of San Antonio that was a pro se inmate who admitted that his claim was a healthcare liability claim. So in 44 years, there's been no case that has taken this position. The principle would only apply to state actors and would only apply to deprivation of civil rights. So how it could be argued that that would open the floodgates is quite hard to understand. And you'll note that in the brief that was filed by the state, they have said that if the court allows this case to proceed, that this case will metastasize. So they're calling Mr. Bagley's claim a cancer, so that an individual that tries to enforce their civil rights is apparently now a cancer on the state of Texas, according to the state. And this is a case in which 5 individuals jumped Mr. Bagley. And we're not talking about an injury. We are talking about a lacerated spleen. We are talking about approximately 7 of his vertebrae had all the spinous processes broken off of it. We are talking about an individual who had a punctured lung, and he collapsed from internal bleeding and died. Just to add more interest, they attempted to resuscitate him with an external defibrillator that had no batteries working.
Ms. Klein, let me ask you something.
Yes, ma'am.
We have to view this within the context of the mental health facility within which this occurred, and that the patient, from what I can tell from the record, was going through a manic state and was having some type of a manic incident, which of course medical health professionals are trained that it's very, very important to handle these types of matters, because persons who are in that type of mental manic state could be very, very dangerous to themselves and others. And in light of that, how can you differentiate what was the provision of healthcare, which was trying to restrain an individual who is in a manic state from a violation of civil rights?
Well, first of all, the statute itself defines medical care, healthcare, as medical care, which is medical treatment. In that moment, they were not treating him for anything, they were restraining him. But also, the state relies on Loisiga as their seminal case, but Loisiga is an individual that talks about a voluntary submission to a physical examination. This person was held involuntarily under a civil commitment order. He did not commit to being there. He did not consent to being there. He was there against his will because of the fact that he was mentally ill, no doubt. But the issue is the nature of the wrong. It's not, did they give him the wrong medication? Did they give him the wrong shot? It is that 5 people jumped him and lacerated his organs, and the master trainer for the facility even said, and it's in the record, that in no way was this a proper restraint, that they violated.
But what I'm saying is if we hold that an amount of force was required to restrain the patient because of his mental health condition, if we were to hold that, then where do you draw the line between that type of restraint, which arguably here would be negligent if they did it in such a way that ended up with broken bones and injuries? But that's the very definition of a negligence suit within the realm of a healthcare liability claim.
I would submit that it is fairly clear that these psychiatric nurse assistants were angry that the man had punched one of them, and that is the reason that 5 of them jumped him. And they
Ms.
took
Klein,
him to the side.
what type of expert would be required to properly opine on the reasonable amount of force that should be used with a patient exhibiting this type of behavior? Would that not be a physician, or who else would give, or a nurse? Who else would give that testimony?
That gets into the issue of retained experts versus non-retained experts, because the individual who worked for the institution, who was the master trainer, would not be a retained expert by the plaintiff, but he opined that this was not a proper restraint, that it was wrong in every respect, not only from taking him down sideways instead of backwards, etc. But not only that, you would have, when you're talking about excessive force, you can also look at the inmate cases, and there are a number of inmate cases in which the restraint can be from the standpoint of a securities expert, or from the standpoint of a facility expert who is not a medical person. That
So
would
then,
be,
would we consider the setting then? Because you seem to be suggesting that, when somebody gets arrested and they're put in a police car, and, if an officer uses excessive force in that context, that the same type of expert would opine on the amount of force necessary in this type of facility with a patient who is experiencing a medical issue.
it might or it might not, depending upon the facts. I think the facts would be important, but what they're talking about here is making the expert report outcome determinative. And you need to also recall that in federal court, this would not be an issue, because you're not required to marshal evidence and prove that you have a valid case before you do discovery. And the reason why,
though, what Felder asked us to focus on is not the timing of when you're required to prove it, but is what you're having to prove under the TMLA different from what you're having to prove under your excessive force claim. The way Felder puts it is that we should focus on whether the two standards will frequently and predictably produce different outcomes. So can you help us with that? How would applying the TMLA here produce a different outcome than you would get under just in federal court, say?
If you go to federal court, you are not required to marshal your evidence and prove that you have a meritorious case before
But you would at trial.
Oh, of course.
Okay,
of course.
so that if we say that's a timing issue, is there anything else that's different from state and federal court about why the outcome would be different? The result after trial, for example?
Absolutely. For one is that the question is, in federal court, if you have an expert report or you can't get your expert report completed, you can apply to the court for an extension. You can apply to the court for more time. The TMLA is absolutely.
And I understand those procedural differences, but I'm asking just in terms of what you have to show to prove the claim. of excessive force in federal court versus what the expert is going to have to opine on to satisfy the standards under the Texas Medical Liability Act. Is there a difference
Yes.
in what you're having to prove as a
Yes.
substantive matter to show liability? And what is that?
As a matter of law, in a TMLA case, you have to have an expert who is going to define the standard of care and who is going to opine what is the breach of the standard of care. In a 1983 case, you can try it without an expert. You don't have to have an expert. And more importantly, on excessive force cases, you're talking about a non-uniform outcome because we're talking about under 1983 giving full recovery to individuals who have been deprived of their civil rights. And who are the people depriving them of their civil rights? These are state actors. Now, in a TMLA case, you are the patient. You can demand your records. You can get your hospital records and give them to an expert. You are talking about trying to get records from a government agency who very often will not cough up those records. They may have an open records request complaint. They may ask for an attorney general's opinion, or they just may flat out not give them to you because they are records of a state actor. And if they can delay for 120 days, the most important thing that's so different here is that in our case, we had no idea that it was the state's intention to make this a healthcare liability claim because we didn't plead it that way until after the deadline to provide an expert report had expired. That's not a time issue. That is a dispositive issue that the state can lay behind the log and say, oh, you know what? In this case, why don't we make a run at saying that the smelly trash can caused you to have an allergic reaction is a healthcare liability claim. Nobody's ever thought of that before, but why don't we wait till the 120 days and then tell you, oh, by the way, that was a healthcare liability claim and you're out. This is a way of completely upending the ability of a plaintiff to formulate their case. And these are not like the cases where they've joined the civil rights claim with negligence or with premises. No, this was a pure civil rights case. And the law says you should not have the less rights in the state court than you do in the federal court. And
are there any federal cases you would point us to on similar facts involving excessive force that say you don't need a medical expert?
I hadn't prepared to answer that question specifically, but I think one would be Kingsley versus Hendrickson. I think that was an excessive force case, but I'd have to go back and double check that. I'm sorry?
Yeah, Ms. Klein, do you concede that some Section 1983 claims would or could qualify as a healthcare liability claim? Or is it your position that no Section 1983 claim of any type could ever, under any facts, qualify as a healthcare liability claim?
I would answer that there are probably cases that have not been pled as 1983 cases, but have been pled as healthcare liability claims, which could, in theory, be both. But I can't point you to a case because a lot of lawyers just don't practice under civil rights law.
I'm asking about the opposite scenario where it is pled as a 1983 claim, civil rights violation. Is it your position that no such pleaded claim could ever qualify as a healthcare liability claim?
Are you asking me whether or not it should properly be held to be a healthcare liability claim, or are you suggesting that it would have to be? I'm not understanding the question.
Well, I'm saying under the definition of a healthcare liability claim, 7401A13, is it your position that if a plaintiff pleads facts that meet that definition, but does not assert a claim under 74 and instead asserts only a claim for civil rights violation under Section 1983, is it possible that such a claim could ever, in fact, qualify as a healthcare liability claim?
I think it would turn on the way that it's pleaded and the type of evidence that's needed to sustain the claim. I cannot think of one that would, but the issue is that if you're making a standard of care argument and you make a standard of care argument against a healthcare provider who is also a state actor, then I could see that theoretically that would be the case. This is not a standard of care case. The Twin Oaks case talks about the purpose of the TMLA, and it says to control medical malpractice insurance rates. There's no medical malpractice insurance here. To tamp down malpractice cases, to decrease the cost of claims, and to reduce the cost of healthcare. Those were the legislative purposes of the Texas Medical Legal Liability Act. Not one of those has an application to this case. And the courts looked at the inconsistencies between the state and federal law, and a case of that is Moore versus Brunswick Bowling, and says that you have to be guided by the policy of the act in determining whether or not there was preemption. Now, the state here today is saying that the 13th court ruled improperly on preemption, but the policy of preemption is to not have non-uniform results. And in the Felder case, they said that non-uniform results argue in favor of the supremacy clause. And in 1983, there is no liability for breach of the standard of care. And Doe versus Taylor ISD is a federal case, 1994, out of the Fifth Circuit, that defines that and says if there's not a standard of care issue, then in 1983, you don't have a medical TMLA case.
So, Ms. Klein, Mr. Davis alluded to the requirement of an excessive force 1983 claim, in that the plaintiff must show an injury that resulted directly and only from the use of force that was excessive to the need. Is this sort of 1983 case a case that does involve a standard of care, because a jury will be asked to evaluate whether the force was excessive to the need, and also whether the force, the use of the excessive force caused the injuries, as opposed to the medication or some other non-excessive force? So is this a case where there really has to be medical testimony about whether the care was excessive to the need?
No, this is not a case about care, because the statute says it has to be directly related to the administration of medical care. And that's why there's never been a single reported case that has talked about this. This is an excessive force claim that violates the Constitution. You know, the 13th court tried to talk about the Health and Safety Code, which is totally irrelevant, because 1983 says you only have to show a violation of a civil right and show the right was deprived. So like Moore versus Willis Independent School District is another Fifth Circuit case in 2019. That the healthcare liability claims have been interpreted broadly, but there are exceptions. Products liability in Ray Temple, Doctors Hospital versus Mejia, which is a waxed floor, TC versus Caius, which is a sexual assault during an examination. Those are cases in which they have been determined not to be healthcare liability cases. So there would not be a need for expert testimony. And if you did, it could be law enforcement, it could be a restraint expert, it could be a facilities expert, none of whom have to be medically trained. This issue is not whether or not it took 5 people to restrain this one man, because their own master trainer said there was nothing about this restraint that was correct. It was totally wrong. You never have more than 2 to 3 people involved in a restraint. And so this is a case where there was deliberate indifference to this gentleman's needs. And the fact that they left him lying there on the floor for 15 minutes, which is undisputed, and that the master trainer said it was a wholly improper restraint, which is undisputed. So that it is our position that it is not a healthcare liability claim, and that position taken by the 13th court should be reversed.
But Ms. Klein, what would you argue if we were to say that it is a healthcare liability claim? Then what would your argument be succinctly about the preemption issue?
that the preemption is in accordance with the federal civil rights statute, that the federal constitution does not allow the states to constrain the application of federal civil rights in state claims, and a different result would result in the state court than would result in the federal court, and that thereby, by definition, because it violates the purposes of the statute, then it would be an impermissible restraint on a federal civil rights, and that is why it's preempted.
Any other questions? Thank you, Ms. Klein.
Thank you, Your Honor.
Mr. Davis, I believe you have 5 minutes.
Yes, thank you, Mr. Chief Justice. If I could start by addressing Ms. Klein's assertion that the state lay behind the log here. That's not accurate. We identified in our answers the fact that Chapter 74 would apply here, and the court can look to the clerk's record at pages 41, 46, and 70 to confirm that. The second point I wanted to address is something that Justice Busby, Justice Bland, I believe you and Justice Boyd touched on, about the distinction between a 1983 claim and a healthcare liability claim. Certainly there'll be some 1983 claims that aren't healthcare liability claims, but again, the concepts are not mutually exclusive. And if the question is whether a force was excessive to the need in the context of a restraint of a patient, where the restraint was part of the mental health care he was receiving, that's something that is going to need expert testimony. I think Ms. Klein has confirmed that today. And it's a healthcare liability claim and a Section 1983 claim for that reason. There aren't a lot of examples of
Davis, could you address a scenario in which perhaps the expert, and what we heard from your friend on the other side, is that there could be a scenario where you don't actually need to retain an expert because the expert testimony necessary to prove the case could have been supplied by an employee, sort of, let's just posit, who was filling out an incident report and kind of provided in writing as an admission the expert testimony that would be needed to make out the case. In that scenario, it seems to me that the application of the state procedural rule would be erecting a substantive requirement that wouldn't be present if the claim were pursued in federal court. How can you address that?
Sure, Justice Huddle. And I guess I would say that there would be no difference because in either setting, there's going to have to be expert testimony to prove this claim. And the TMLA just accelerates the presentation of that evidence. And the need for expert testimony is also part of what makes this a healthcare liability claim. So, and I think this went to also a question from Justice Busby, that there are not going to be different outcomes in state and federal court here, because again, the kind of claim we're talking about here inescapably requires expert testimony, if not for the restraint or the medication, then for causation. And that's not going to be something that can be proved from what's already in the record today.
But not necessarily a medical expert?
I would think it probably would need to be a medical expert, Justice Boyd, but I suppose there could be experts on restraints that may not fall into that category, but certainly causation, the use of the Lucas device, how did that play into this? What was the role of medication? What was the underlying condition? Excited delirium, that's a term that appears in the record. I don't really know what that means. I don't think most lay people know what that means. That's a matter for medical expert testimony.
Does it matter that the Civil Rights Act requires purposeful or knowing that the force used was objectively unreasonable, and healthcare liability claims are focused on the negligence of the actor?
No, I don't think so, Justice Bland. Again, because of the breadth of the healthcare liability definition, the court doesn't look to the labels or how the plaintiff tries to characterize the claim, but rather to the facts alleged. And if those facts.
But those are two different elements, right? There's a scienter element for an excessive force 1983 claim that's not present in a healthcare liability claim.
That's right, Your Honor. But even so, there can still be a 1983 claim that is a healthcare liability claim, and that's what we have on these facts. And so the only real question here should be preemption. And I see I'm almost out of time, but I believe I've covered the ground, and that the court should just follow Global Santa Fe, because it's very similar to the expert analysis, expert report requirement here.
Mr. Davis, assuming we agree with you on both points, this would seem to be a fairly good candidate for remanding in the interest of justice, because there's really no clear answer in the case law before. Is there any reason why we should not consider that in this case?
Well, in our view, the case law is very clear that this is a healthcare liability claim. And even though the specific 1983 preemption argument hasn't come up before, Global Santa Fe was quite clear on this too. And so I don't believe there would be a need for any reconsideration of those decisions.
Any other questions? Thank you, Mr. Davis. The case is submitted and the court will adjourn, the clerk will adjourn the court.
Oh, yay, oh, yay, oh, yay. The Honorable, the Supreme Court of Texas now stands adjourned.
Nice job, Katie. Oh, sorry, you're on mute.